We are live. It appears as though we were waiting for me on the live stream. Okay, you know what? I'm going to close my iPhone down. Good evening, everybody. It's late. Everyone's tired, a little cranky. I'm not cranky. How's everybody doing? Let's just see if we're live. Everyone hit like a Y or a yes or a smiley and emoji. We're live. 25 seconds. Okay, while people come into this live stream, Supreme Court doesn't come with guacamole. Okay, we're obviously engaging in an ongoing conversation. While everybody tunes into the live stream, we'll get things started. How's everybody doing this evening? Now, here's the question. Light on or light off? Or it makes no difference. This is my high-tech lighting. We're live. Okay, awesome. I'm gonna leave it like that. I look a little yellow, but I'm not gonna fix it. Okay, while people stream in, who saw today's video on the Senator Elizabeth Warren versus Senator total blank, Bernie Sanders? Who saw that? Who saw that and can seriously watch the debates as though it's not a joke? It's impossible. It's impossible. Okay. That video was frustrating to make because it's difficult to try to present facts objectively without commentary, without humor for that matter, or snide humor. It's preposterous. The line of questioning was infantile and okay, whatever. I trust everyone's seen that video because that video is now, it's like less than 6 hours, I think it's up to 20,000 views, maybe. The video that we're going to be talking about, it's a Canadian subject, so probably a little bit less demand, and we're going to have a little bit less interest, except for the Americans who want to come and like poop on Canada as to how minimal free speech. No video of you. Who said John Dowd, no video? Does everyone hear video and audio properly? Enter a Y. And let's see if we get this. Audio, video, no minimal delay. If I go like this, wax on, wax off, we're good. John Rivera, did you see the last bit after? Okay. Is there video of me and is there audio of me? 10 on 10. Good. Okay, good. So whoever said amazing, a live stream. Thank you. Colette Yamazaki, nice to meet you. Nice to see you. All good, all good, all good. Good. Okay, we're good. I'm using StreamYard, and I'm doing the comments through StreamYard, so there's a bit of a delay from YouTube, so that might explain a few things. Okay, we're going to delve into some Canadian law tonight. It's going to be of particular interest to Canadians, less interest to Americans, but maybe of interest to Americans so they can judge us, knowing that their system is not that far off and that, justice is human, courts rule. Courts rule based on other things than strict law. St. Nicholas, I saw your comment. And I'm going to play with this while we do this. This is awesome. What do we see here? Did he saint? Did he? Okay. We'll get like 5 minutes. I'll start getting into the substance. The first 5 minutes is the intro. Let's just see who's here without playing favorites, because I'm just going to go pick some random names. Sleepy Guy Khan, good. Nice to meet you, Sleepy Guy. A name I do not recognize. Jason Bone, it's all partisan. Part of a conversation I'm not familiar with. Pineapple Knight, name looks familiar. I wish you would cover Canadian politics more than American. I'm sure every Canadian would like that. Canadian politics is just less interesting by and large. We have some big issues, but by and large, we have big issues, just like 1/10 as many as American. Just size of the market, size of the interest. And, to such a point that what would otherwise be of shocking interest in the States is unnoticed in Canada. Not, least of which is the SNC-Lavalin scandal, which I've done a bunch on. You know what? I have to actually be careful as to which comments I bring up because I don't want to get in trouble. More Canadian politics would be nice, actually, but I agree with the less interesting bit. They're less interesting, and even the ones that are shockingly interesting, it has a minimal market because nobody outside of Canada appreciates how serious it is. Rebel Media versus the Federal Debates Commission, CBC versus the Conservative Party, SNC-Lavalin scandal. In the States, front page news for forever. I'm going to get to all of the live stream. If anybody notices I miss a live stream, let me know, please. Steve Stevens, when you can, okay, say the most Mackenzie Brothers thing you can think of. I believe this is a Canadian subject. Mackenzie, like the former Prime Minister Mackenzie, or Spud Mackenzie. Okay, I don't know, but thank you very much for the super chat. Okay, so let's get into it. For those, we're going to do the Court of Appeals from British Columbia, the transgender teen who consented to transition therapy from female to male. Father opposed, mother consented, ended up in courts, as do all family battles, and not just to do with transitioning for transgenders, but like family stuff ends up in courts, and we'll get to it. But we're gonna get to all of this. Okay, summarize the facts. 6 minutes, 6 seconds. We're starting with the summary of the facts. Incidentally, if anybody wants to get a comment pinned on a video, on a live stream, anybody who chronologizes or timestamps the videos, I don't know what would happen if we had more than one person doing it, but I will pin that comment so that people can get to the important stuff based on timestamp. Let's do the fact pattern first. Spend a few minutes on it because we only need to go into so many details. For those of you who have not seen my vlog from the other day, which was the British Columbia Court of Appeals decision, confirming in part, overturning in part the lower court's decision as relates to a transgender teenager who wants to transition and follow the transition therapy from female to male at 14 years of age at the time of the appeal. Basic fact pattern is that parents are divorced, 11-year-old kid, born female, identifies as male, publicly identifies as male as of 11 years of age, socially identifies as male between 11 and 12 for 2 years, publicly identifies as male, changes their name, starts doing public activities under their male identity. And I'm saying that in the sense that they are publicly identifying as male, change their name, and therefore go to school now and ask that they be recognized as their new chosen gender identity as opposed to that with which they were born. Parents are divorced, so obviously things are already off to a bad start. At about 13, 14, the child decides they want to transition from female to male, which, as far as I understand, doesn't involve, a lot of people in the comment section are saying it's like, mutilation, cutting off body parts. From female to male, it's hormones or hormone blocker. I don't exactly know the therapy in and of itself, but it's hormone therapy. The child consents, the mother consents, and they go to consult healthcare professionals who, first of all, I should back up a little bit. They formally diagnose the juvenile or the infant in this story as having gender dysphoria, which is severe discomfort with one's born gender. They identify with the other. It causes distress, and it's a clinical diagnosed condition. AB, who is the infant in this, is diagnosed with it and goes to seek the help of medical professionals. It's determined that hormone therapy is the appropriate or best course of action, and we're going to get back to this. The infant, AB, consents, the mother consents, and they decide to go through with hormone therapy. The medical professionals discover that the father doesn't know exactly what's going on because, as you can imagine, in divorce proceedings or in the situation of divorce, communication between the ex-spouses is not always 100%. Okay, so that's the basic fact pattern. Then the medical professionals find out the father's not aware of what's going on and what the mother and child have agreed to. They notify the father. The father says, after some difficulty, communication, says, no, I don't consent. And then they try to organize some meetings between the father and the healthcare professionals. Father says, hell no, I'm not doing this. Father petitions the court for an injunction to prevent AB, we're going to refer to AB or the child, from getting this therapy, this treatment. the father petitions the court for an injunction to prevent the child from getting the therapy. So an injunction, we've talked about it before, court order enjoining someone to do or to not do something. This court order, which was heard on an urgent basis, was to prevent the child from getting the therapy, this hormone therapy, to prevent him from doing it. And at the same time, so apparently the first order was granted temporarily because this is to be heard on an expedited basis. At the same time, roughly speaking, AB, the child, files the child's own court proceedings to to ratify the consent given under what's referred to as the Infants Act in British Columbia, and for various orders under the Family Law Act, which is the law that applies for family law in California. And full disclosure here, by the way, this is British Columbia law. This is not Canadian federal law. This is not Quebec civil law. This is provincial law. I'm not certified to practice in the province. I haven't studied British Columbia law, period. So it's not my area of expertise. My learning curve is in going and seeing these laws and to see what the various provisions are, to see what exactly is going on. Uncivil law is in the house. Love this topic. Followed the TX case too. Texas. So apparently in the States, there was a very similar case. I think the child was younger in the Texas case. It's disturbing stuff. Need to cover this myself soon as well. Good luck. Uncivil law, for those of you who don't know, is another one of the fellow YouTubers out there. Great stuff. Great content. Longer format, I think, than myself. Great content. And thank you very much for the super chat on civil law. It is. We're going to get into this because it's actually what's unsettling about this. It can be dissociated entirely from the underlying issue of transgender therapy, but rather the broader issue of state, provincial government oversight or intervention in parenting and parental rights. And we'll get there. So where were we on the fact pattern? The fact pattern was the father petitions the courts to prevent his child from having this therapy. Child petitions the courts to ask the courts to pre-act, basically to approve, validate, that's crazy, to validate the child's consent to the therapy and to render certain family law act orders to the family. And that's the fact pattern. It is an unfortunate situation from the beginning, and I'm going to say something in a second right after I get to Alex Victor. Thank you very much. Notwithstanding morality, is there a legal possibility that if the child goes through with any changes, that the father can deny family attachment? Well, I don't know what you mean by family attachment, but I suspect you mean, can the father refuse to support the child now that the child has decided to do something? I don't think so, and I'm going to say that with full caveat that I'm not 100% certain. Because I don't believe that child support is not by consent of the father and by consent of the father of the child's decisions. So I don't think so, if that's what you meant by the question. So that's the fact pattern. It's an unfortunate situation because you have divorced parents, so you have a broken family, you have a child with a diagnosed condition, whatever you want to call it, but it's a diagnosed gender dysphoria. Recognized by medical professionals. So it's a psychological dysphoria. Parents not talking. Father is at this point obviously not talking to the kid. Kid's not talking to the father. They're not getting along, and we're going to get into that in a second. And this is what happens. I mean, this is the fundamental thing that most people don't understand or don't appreciate really, is that it's not a question of the courts intervening in family life. It's that when the poo-poo hits the fan with the families, there's no other recourse when things are totally dysfunctional than the courts. And the courts are not the proper place. They're not by any means the best resource or venue to resolve what are fundamentally family issues. And whenever they do it, it's fundamentally imperfect and borderline, even problematic when they get it right to some extent. It's resorting to the courts to resolve family issues is not ideal. It's problematic to begin with. So to say that the court orders that the court renders in the case of family law stuff, regardless of what it is, are problematic, they're always going to be problematic. I mean, imagine having a court system adjudicate and resolve on fundamentally family issues. It's an inconceivable situation from the beginning, but when things are dysfunctional and when there's no other recourse, that's the bottom line recourse. Viva Frei, you should explain to Americans, etc., the difference between how federal and provincial law works, civil versus criminal. Okay, so I'll do it if anybody doesn't know. I think it's sort of the same thing as in the States. Canada has a civil law system in Quebec and a common law system of legal system in the rest of Canada. Each province has its own set of provincial laws to some extent. There are federal laws that are overriding, like criminal laws, tax laws, bankruptcy laws, which are federal jurisdiction. Each province can enact its own provincial legislation. Every province except for Quebec is nonetheless a common law province in that they abide by common law statutes. Quebec is a civil law province, meaning that we have a codified set of laws because we are descendants of the French and Napoleon. So we have a Napoleonic code derived from the Napoleonic Code. So that's sort of like the difference between states and provinces, federal versus state law. Some laws are federal by governance, others are state by province by province, which is why in this particular case, it's a British Columbia Court of Appeals decision in, what's the word I'm looking for? Not enacting, but rather interpreting and applying provincial law. The Infants Act was a British Columbia Act, and the Family Law Act, which is a British Columbia Act. Okay, Jessica, I missed something here. Jessica Cry says, the problem is puberty doesn't care about an arbitrary age set by law. Puberty to the transgender child can literally be torture and often leads to suicide. And we're going to get into this because this is where we're not just in an imperfect, first of all, thank you very much, Jessica, for the super chat. We're not just in an imperfect situation in law. We're in these exceptional, extreme situations of the human experience. And that's another thing that people don't fully appreciate is there's an expression that bad cases make bad law. And I don't want to use the word bad because it has a judgmental tone. Extreme situations don't create the generalized precedents that everybody thinks they should. And this is the reality. By the time you get to court and by the time you get to a judgment, you're dealing with situations that are so extreme. Not only could they not be resolved before going to court, even when they get to court, they can't be resolved before a judgment. And so you need a judgment to resolve these extreme cases that cannot otherwise be resolved. And then they turn into precedents, but you're making precedents out of these extreme unresolvable cases that require a judge to intervene. In commercial corporate matters, who gives a sweet bugger all? But in family questions, these types of questions, it's very difficult to get the right answer, and it's even more difficult to get the court to appreciate the right answer. And even if they do, even having a court impose the right answer is a problem. So we're dealing with a situation which is tragic and I don't want to say sad because that also implies judgment, but unfortunate situations which are based in problems and real problems of a transgender teenager who has internal issues that that seeks medical advice and then it leads to problems with the family, and then the family doesn't get along, end up in court, and then you expect the judge to be able to render the most appropriate judgment. It's an impossible situation from the beginning, and it's one that might not have a happy ending one way or the other, and that's the problem. Okay, so that's the fact pattern. I get into the whole thing which I talk about often is that law is justice is human, and you get into this situation where you're not just dealing with questions of law, you're dealing with people. And everybody's like, everybody looks at the bottom line of the judgment and says that's an injustice, it's an overreach, it's offensive, and we'll get into it. They look at that and they say, okay, this is the bottom line of the judgment. It's disgusting. How can the courts do that? They weren't there to see the parties plead, to see the conduct of the parties, to see how they reacted, to see how they reacted with the judge. They weren't there to see the human element. All that they get is the bottom line legal element, which admittedly on its face can be shocking. And so what ended up happening in this case on the judgment on the merits, right? So there was the father petitioned the court for an injunction to prevent his child from getting the hormone therapy. He petitioned the court. Okay, so that was one part of it. The child petitioned the court to recognize the consent is valid and to render certain orders under the Family Law Act. Now, a lot of people said in the comment section, this is a 14-year-old kid. It's lawyers drafting this, not the kid, because the kid doesn't know the provisions of the Family Law Act. And there's no question about that. You're dealing with a file where there's a mother, the child, the father, the province, medical associations, activist associations, hospitals. You're dealing with the 12, 13, 14, 15 parties, various lawyers, all with their various, call it agendas, or at the very least interests. But you have the child being represented by an attorney, I presume. In fact, yes, she was. So you have a lawyer saying, okay, well, this is what we're going to petition for. You want your consent to be deemed valid? That's going to be one order. We want your consent under the Infants Act to be deemed valid. We're going to go for family law orders, and that comes into the first judgment. Now, Family Law Act, no, sorry, not Family Law Act, we'll go with the Infants Act. The Infants Act, which has a very peculiar name under British Columbia law, is basically a law that says that an infant can validly consent to medical treatment, even if it's unnecessary, not unnecessary, but rather cosmetic, therapeutic, non-essential. They can consent to it, even if it would qualify, I think the wording of the law was a trespass of their body, but basically, even if it's invasive, the infant can consent to the treatment, notwithstanding the opposition or lack of consent of their parents, to the extent that healthcare professionals have deemed it to be necessary or in the best interest of the child, and the child understands and can consent to the risks of the procedure. So that is what the Infants Act, in so far as we're relevant to this is concerned, says. The child, the infant, by the way, who can be 18 and under. Under 19 is an infant under this Infants Act. It's a preposterous name. Could have been called the Minors Act, the Juvenile Act, whatever. Infant is 18 or under. Infant is under 19. Can consent to treatment, even if it's therapeutic or cosmetic, invasive, notwithstanding parental opposition, if Medicare professionals deem it to be in the best interest of the child and deem the consent of the child to be valid. That's the Infants Act. The Family Law Act is a lot more complicated and something that I didn't really delve into, but the bottom line is that you can render certain orders under the Family Law Act, which would govern the interaction between the family members. So AB petitions the court to recognize consent is valid under the Infants Act to the hormone therapy, and to render certain orders under the Family Law Act, which were to basically prevent the father from interacting with AB, to the extent that, to prevent the father from referring to AB by female pronouns, to prevent the father from pressuring AB not to consent or to cease the hormone therapy. It went one step further, and we'll get into it, is ultimately the first order of the judge. It was Judge Bowden was the first order. Bowden J, Bowdenj. The first order of Judge Bowden was that the father shall not refer to the daughter, refer to his child as a daughter, as a girl, shall not refer to her with female pronouns, shall not pressure her to stop the hormone therapy, and continued attempts to do so would be deemed to be family violence under the Family Law Act. Furthermore, the father could not publicly discuss the case with the media. Now, that was the order of Judge Bowden, which a lot of people rightly, unequivocally took issue with, is that the court, it was overturned in part. The court basically said certain aspects of freedom of speech and parental rights shall be deemed to be family violence under the Family Law Act. If the father, in dealing with his own child, refers to AB as a girl, female pronouns, tries to talk AB out of following the procedure, that shall be deemed to be family violence. I mean, that made the news, and rightfully so. What also made the news was that the father was prohibited from discussing this publicly with the media. And it is shocking on its face, period. I mean, to have court proceedings effectively have a gag order placed on them, to have people's freedom of speech to discuss things limited, it's shocking on its face, and there really is no but to it. The question is, in the context of this court file, how did it happen? And this is where I get into the aspect of justice is human. And Mandatory Carry, I'm going to get here. Okay, hold on. Mandatory says, at work, so I can't stay and play, but keep fighting the stupid. Well, thank you very much, Mandatory, for the super chat, and it's good to see you. I haven't seen you in a while, but that's nice to see you again. How did it happen? That's the question. And now it's justice is human. You have people in this file who have had hearings, hours and hours in front of judges where the judges get to know the parties, get to know the people, and then render orders as a result. When AB filed the proceedings, AB anonymized all of their proceedings. And it makes sense. AB's a minor. This is a very touchy subject. You, for reasons we'll get into in a bit, don't necessarily want to publicly identify the doctors involved, the parties involved, the lawyers involved even, because lawyers can be the object of harassment as well. AB anonymized their proceedings. CD, who's the father, did not anonymize his proceedings. So he files for an injunction, names on a public document his kid, the doctors involved, the parties involved. And, that is going to piss off anybody. And regardless of how you feel about it, there are things you can do in a file out of spite, out of anger, out of a sense of justice. But there are things you can do in the file that are going to have an impact on it. And so you step into this file before Justice Bowden even renders what was, by the Court of Appeal, deemed to be an overreach by a judgment. You step into the file before any judgment is rendered, and this is what you're dealing with. A kid going through a crisis, family disputes, and the father filing court proceedings. It's deliberate. The only question is whether or not it was malicious versus innocent, unredacted for the parties. Anybody can go read it. Anybody can read all these private medical details, private psychological conditions of this child who's a minor. They can get the names of the doctors, and people do, and people start harassing the doctors. So you start the file off before any order has been rendered. With that, the way the judges are going to be looking at the parties throughout this file and rendering judgments accordingly. So by the time it comes around after a hearing, and I suspect the father's behavior didn't get better, the judge says, okay, you're going to not be allowed to, what might be, in our opinion, be deemed to be sort of psychological abuse of your child. You can't do it. We're going to prevent you from doing it, failing which it's going to be deemed to be family violence with all the sanctions that might imply under the Family Law Act, and I have no idea what they are. You can't talk to the press because it seems that, by the court's opinion, your intent is not necessarily to have a public discussion, but rather to have a public expose, which are two different things. And so we render this order, which is untenable in law, but if you think it's untenable, go appeal it and have fun. Whereas, who knows what might have happened had the father filed anonymized proceedings to begin with, maybe interacted with the judges differently. Maybe the court order from the initial one from Bowden might have been different, but who knows? And so that's it. So that we get to the first judgment, which is, I don't think there's many people who would say that it wasn't an overreach. Imagine a court telling a father how they are to interact with their child, what words they are to use when interacting with their child. And it's not, you can agree on the most extreme examples, a father who calls the kid expletives, psychologically abuses the child in manners that most people consider to be objective, where now you're dealing with things which are highly subjective. Some people might say referring to AB as a her can qualify as psychological abuse. And, a great many other people say, no, it doesn't. It's the father's choice. Whereas referring to AB as an effer or an sh or any other swear word, people say, yeah, that's psychological abuse, and the father should not be allowed to swear at the child. And so you get a judge now who is no longer necessarily in the spectrum of objective abuse, but rather potentially subjective abuse, has seen the way the father has behaved, has seen the kids, has seen the mother, and has to render an order. And their judgment is influenced accordingly. Stephen Britt says, it's clown world. Appreciate the great work you do, brother. Thank you very much, Stephen Britt. It's tough. It's tough to the clown world thing. It's a meme that's taking a life of its own. Thank you very much, Stephen Britt, for the super chat. It is tough. I can appreciate that for outsiders, even for insiders. It's tough to look at Canada and say, okay, we have a court of appeal affirming a judgment of the Quebec Human Rights Tribunal ordering a stand-up comedian to pay $35,000 to a celebrity kid for a joke. I can appreciate how people look at this and say that this is judicial activism gone run amok. I can appreciate that, and I appreciate even this. Like, people don't necessarily appreciate the nuances of law, but they can look at this situation and say, it doesn't make sense that a judge is usurping the parental rights of the parents, rendering orders that are effectively parenting decisions, depriving people of freedom of speech, and deeming certain speech that is otherwise absolutely innocuous to be deemed as family violence. I mean, yeah, people can have great difficulty understanding this. So that's what Justice Bowden does. Renders this order that says, if the father continues to refer to the child as a her, female pronouns, continues to pressure the child to stop the hormone therapy, it's going to be deemed to be family violence. Can't talk to the press, can't talk to the media. What does the father do after that order? I don't know which came first, but the order was obviously appealed. That's why we have the British Columbia Court of Appeals decision. But what does the father do? Starts giving public interviews with the Federalist, with I'm going to forget the name of the other one. It'll come back in a second. It was something to do with like Culture Guard. Culture Guard is what it was called. The father, notwithstanding that, gives public interviews, and doesn't just give public interviews, gives public interviews, not just identifying the parties, again, his kid, discloses court documents to these media outlets, unredacted. And what do you think any other judge is going to view that as later on down the line? It's not that the father gave interviews, redacted, didn't mention names, talked about the file, talked about the principles in general. The father went out, by all accounts, gave interviews with conservative, apparently they're conservative. I mean, I know of the Federalist, I don't know of Culture Guard, but based on the name, I can imagine it's conservative rightish. Gives interviews, discloses public information, discloses private information of the parties, identifiable information of the kid, the doctors, notwithstanding the first court order. And people, in the comment section, we got a kid coming downstairs who's crying. The kid, the judges, what was I going to say? No, you have people in the comment section saying it's a stupid court order, don't respect it. One person used, everything, it's the Godwin's law. Everything goes back to World War II, not to use the words that are going to get this video shut down, but other fascist regimes had their laws. Would it have been the moral thing to do to abide by those laws? It's an oversimplification. It's a cliched analogy. The bottom line is you have an order of the lower court. If you vehemently disagree with it, the first thing to do is appeal it, not to hold that judgment in contempt. I don't know if he appealed the decision before doing the interviews. It really wouldn't make much of a difference. The bottom line is there was a court order. As overreaching and overarching as that court order was, you appeal the decision if you disagree with it. You don't violate it if you disagree with it. He may have done both, but he certainly did both. So the father violated it, gave interviews, identified the minor. It's a minor nonetheless. It's a 14-year-old, 15-year-old kid that the father, either out of the goodness of his own heart, out of anger, out of spite, out of vengeance, out of frustration, nonetheless publicly identifies in violation of an existing court order that had not yet been overturned by the Court of Appeals. There was a second court order by Judge Marcia. Before we get there, Dame of the Dammits. That's a good name. The court was just as reactionary as the dad bias. This is a matter of opinion, but you can't blame someone for having that opinion. There's no question. And I would say the court was reactionary, but the court was certainly influenced. The court was certainly influenced by, you can imagine it. Justice is human. You can imagine this. You have a kid who apparently had attempted to commit suicide, who is distraught, distressed, confused, looking for answers. You have a mother that supports the kid, is probably much more amenable to the court, and is probably much more pleasant in her interactions with the court. You have a father who, by all accounts, is angry, wants nothing to do with this procedure, wants nothing of this procedure, who is not quite as cooperative with the court, pleasant with the court. And this has an impact on how the judges come down when it comes to assessing the law as relates to the specific facts. And so, the court, it's not hiding it. The court didn't like the father. The court did not like the father. They didn't like the fact that he didn't tolerate the daughter, I don't want to get in trouble. The court did not like the fact that the father did not tolerate his child's decisions. The court did not like the fact that the father didn't interact with the doctors, was standoffish, was unwilling to compromise, to communicate. Father was uncommunicative. The court didn't like it. And this is the other thing. In family law cases, I never did family law, but we read a lot of family law in bar school, law school. They always turn the judgments into advice to the parents. Like, here is the law. This is our judgment law. But it would be great if the parents could open up and sit down and talk and resolve this on their own without having to leave these very important decisions in the hands of the court. They always do that. They even do it in civil matters, but they do it because they have to render a decision, because that's what they're there to do. That's what the parties have brought to them. They need to resolve it in law as relates to the facts as best as they can, while having that, advice to the parties. But figure it out on your own, because the courts are not best to resolve these family disputes. But so it wasn't the court was reactionary. The court was just reactionary. I mean, the court reacted. The court interpreted and rendered its judgment based on its assessment of the law and its reflexes to the parties. Mediation is, this is where you get mediation is always the best thing to do in law. But then there's a whole slew of problems. Like mediation, you can have an agreement, then you have to ratify your agreement or have it homologated, but you have as many problems enforcing a mediated agreement. But family law is a peculiar beast. It has its own rules. The father was right to stand up for the kid's future, but wrong to not redact info. Father should take the judge to the Human Rights Tribunal. Well, so let's get it. First of all, nobody's taking the judges anywhere. They have immunity, the judges. The father was right to stand up for the kid's future, but wrong to not to redact the info. I think most people would actually agree with that. Let me just see if I can get this up. I think most people would actually agree with that. And I think had the father done that from the beginning, the court might have viewed him far differently from the beginning, and probably would have come down a little differently in the context of the file. But you imagine you have a father whose first action in the file is to file public, unredacted court proceedings, which are, to say they're personal would be an understatement. Like I'll talk about my testicular torsion, I'll talk about my hernia, I'll talk about even my hemorrhoids, as I've done. Like there's certain things which are private, but nobody really cares about, and then there are things which once they are, what's the word? They can't be undone. The bell cannot be unrung. You file a court proceeding that publicly identifies your child by name with gender dysphoria, all of this personal medical information. That bell cannot be unrung. And I don't know if it was bad legal advice or spite or anger or whatever. There's nothing you can do to undo that. And that's going to taint the file. That's going to taint the judge's impression of you. For the rest of the file, it's virtually impossible to come back on that. Aaron Cole says, having had to deal with family court, I can tell you the court doesn't have the time of day for fathers, let alone one who is defying the orders. This is an impression. This is not an uncommon impression that the courts are sided towards the mothers. And it's probably undeniable in terms of stats, but then it depends on it depends on all the other statistics as to what types of files the courts are called to deal with and who typically petitions in that context. But the court doesn't tolerate anybody who defies court orders. I don't think that's not gender specific, gender based. You violate a court order, expect to not have a good time in that file for the rest of the file. There was one more here. Let's see this here. Okay, H7HJ59. That's okay. I'm going to try to figure out what that name means at one point. Really liked your video on this earlier. You did a great job providing a comprehensive breakdown and carefully navigated your way through such a touchy topic. Thank you very much. Very much. And by the way, thank you very much, Aaron. Thank you very much. Let me see if I can figure out this now. Can't figure it out. No way. I just know 7593. Those are all odd numbers. Okay, never mind. But thank you very much. It's the thing is, it's not just a touchy subject. It's the underlying subject is fundamentally touchy. But this ultimately actually doesn't have much to do with transgenderism in and of itself. It has to do with these laws that grant minors rights that might otherwise conflict with parental rights. And the child could have just as easily had any other clinical issue and wanted to consent to something that a father or a parent might say, no, you're not doing that. And ordinarily, in the absence of the Infants Act, that would be where it ends. Like the guardian makes the decisions, and the child, when the child is either emancipated or becomes a major, will make the decisions for themselves. And we'll get into the emancipation. Remind me. Repo Shiz. Viva, keep up the great work. It's interesting that at least recently, it's been mothers for fathers against in these cases. Enjoy the Freedom Bucks. Thank you very much. So a lot of people have been saying that. I have no statistics as to a lot of people are saying, no, the mother's typically supportive of the transition. The father's typically opposing. I have no stats. I have no even empirical observations. All that I can think of, if we're dealing with 5 cases, I don't care if it was 5 one way or 5 the other way. That's not enough to draw any meaningful statistical conclusions. Thank you very much for the super chats. Lost River 77. Just want to say thank you for being awesome. I enjoy all of your videos. Thank you very much, Lost River. I will do my best. This one's a touchy one because it's like, first of all, the situation. I don't want to say sad. I don't want to say tragic. It's not to make the situation pathetic. It's a sad situation. It's upsetting and it's a problem. I mean, the bottom line is the kid has some form of dysphoria. The issue is how to best resolve it, and you have parents who don't agree on the way to best resolve it. And everyone's going to have their opinion on which way is the best way to resolve it. But Devin Stone says on the next vlog, Okay. I got in trouble last time for reading something out loud, so I'm going to have to be a little more careful with that in the future. So where were we? We had one court order saying the father can't do certain things. Father goes out and does certain things nonetheless. The kid comes back, and so they get to the Marcia order, which basically actually expanded the publication ban and expanded the limitations on the father's freedom of speech, and he appealed the decisions. I don't know when he appealed them versus when he gave the interviews, but it doesn't matter. You get to the British Columbia Court of Appeal, and we've talked about this in previous. We've gotten to this in previous. Okay, I think good catch. So I think I may have avoided embarrassment, like with Madam, Mr. and Madam Dixie, whoever had that last one. My wife was in the other room, heard me sing, and she thought I was joking, that I didn't actually get what I was saying. Okay, where were we? So there was a second court order, expanded the publication ban, expanded the restrictions on the father's ability to speak freely, appealed, and then we get to the British Columbia Court of Appeal. That's where we were. Court of Appeals. You do not typically have what we call trial de novos in front of the Court of Appeal. I don't think it's any different in British Columbia than in Quebec. Court of Appeal is going to give a great amount of deference to assessments of fact, witness testimony of the lower courts. Questions of law, the Court of Appeal is just as well placed as the Supreme Court of the lower court to adjudicate on. So questions of law, if there was a mistake in law, the Court of Appeal, no deference. If there was a mistake in law, Court of Appeal is going to intervene. Appreciation of evidence, appreciation of testimony, appreciation of witnesses. The Court of Appeal is going to give deference to the lower court because the Court of Appeal does not rehear witnesses. They're going to read the transcripts. They're going to read testimony. They're going to see the evidence, but they're not going to hear the evidence. And so when it comes to a judge's assessment of credibility, of what's the word? Probative value, or I guess credibility is the word. The trial judge's assessment is going to be given a great degree of deference by the Court of Appeal. So unless it's patently unreasonable, unless the Court of Appeal looks at a witness who is clearly a liar, clearly incredulous, lacking credibility, but for some reason the judge said, I believe this person, the Court of Appeal is not going to get involved in that. So when you get to this situation where you have these two orders that are under appeal, the two orders granting, approving or ratifying the consent of AB, and the other ones relates to the family, deeming certain conduct to be family violence under the Family Law Act and prohibitions on freedom of speech. The Court of Appeal, there you have questions of fact, questions of law. So the Court of Appeal is going to have great deference for questions of appreciation of fact and more liberty when it comes to questions of law. And so what does the Court of Appeal say? They said, yeah, the assessment of the child's consent, we're not intervening on. We have medical professionals, and we're going to get to this. Just remind me to get to the medical professionals who confirm the validity and the what do they call it? Éclairage? It's not éclairage in French, but rather the lucidity of the consent given by the teenager. They confirm that that AB is able to consent, understands the risk, and consent is valid. AB knows the risks. The doctors say it's in AB's best interest. So the Court of Appeal says, okay, we're not intervening on that. There is room for us to do it in law, but we don't find any issue with that. When they come to the deemed family violence, they take issue with that. And that's where, you have to have faith that the court system works. And when you don't have faith, then it becomes a problem. Where it becomes a problem is that a lot of people are going to say the judicial activism works its way from the bottom up. And so you have what a lot of people feel to be judicial activism at the lower courts, and it's just a matter of time before those lower court judges are appointed to the Court of Appeals, and the judicial activism works its way up. It's a very legitimate concern. One sec. Alexander, so children can make these decisions. When does the legal smoking drinking age drop? Okay, getting ahead of myself. First of all, Alexander Moon, thank you very much for the super chat. So the Court of Appeal comes in and says, okay, we're not we've as a pure matter of law, we do have the power to intervene on the child's consent, but we feel that the doctors are professionals. They've given their professional opinions. They've said the procedure is necessary or in the child's best interest. Child understands the risk, can validly consent, et cetera, et cetera. We're not intervening there. Where the court order deemed the father using certain pronouns and trying to pressure his own child not to follow through with this therapy, where the first judge deemed that to be family violence, untenable in law. And they were quite clear on that. They said the judge had no consideration for why the judge said that. The judge just made a bold declaration that if the father uses certain words, tries to pressure his own kid to not follow through this therapy, it shall be deemed to be family violence. And they said, no, that's an absolute overreach. A lot of people are very happy about that because it was kind of a shocking element of the decision. Like the idea that, like I said, not to go over it, but like not using objective expletives was the word, not using expletives to refer to your child, but rather pronouns. You're not calling your child an effing idiot. You're calling your child a gender pronoun. And while calling your child an effing idiot, it objectively psychological abuse that a judge can say by court order, you cannot call your child an effing worthless piece of ass. I mean, you don't need a judge. It's common sense. And if any parent were psychologically or verbally abusing their child, you would expect a court order to say, no, you can't talk to your kid like that. I don't care if it's a violation of, I don't care if it's a limitation of your freedom of speech. You can't call your kid an effing piece of shit. Okay, nobody would disagree with that. Where this judge said referring to your child as a her will be deemed to be family violence. Yeah, okay, that makes the news. Like that makes the news, and that makes the right-wing news. And I'm not saying right-wing in a judgmental sense. That makes conservative news headlines. And that makes I don't even want to call it conservatives. That makes headlines that make them that allow people to cast doubt on the legal system. A judge told a father that the father cannot refer to his child as a her, and if he does, it'll be deemed to be family violence with whatever consequences that would imply under the Family Law Act. That's shocking. I mean, that seems a bit broad. But then the court comes in and says, okay, look. So the Court of Appeal says, yeah, that's untenable. Here's our judicial precedent that the judge, before deeming anything to be family violence, there has to be some sort of justification, some sort of analysis, which there wasn't. When it came to the public discourse, the gag order, the inability, the restriction to give interviews. Look, the Court of Appeal is reassessing these lower court decisions in light of what the father has already done. So it's not as though the father gave interviews without disclosing public and private information, without naming, et cetera, et cetera. Had that been the case, the first order might never have been rendered the way it was. So the Court of Appeal says, yeah, okay, if father wants to talk about it, you can talk about it with friends and family under the condition that they recognize that they're not members of the press and that they understand they can't disclose this to the public. I, again, still have issues with that because I think my personal opinion, as rare as I give it, is that the proper court order, did I answer this? Okay, hold on, I'm going to get to this. My personal opinion is the proper court order would have been the father can talk about the issues generally, publicly, because they are matters of national interest to the extent that he doesn't identify any of the parties or his own kid or disclose any confidential information, private information, etc. But then he can discuss the issues at large because they are real issues. And I have a big issue. It goes back to Tommy Robinson. I have a big issue with the courts willy-nilly, like their bingo cards saying gag order, press, no press coverage. Democracy dies in silence. And the second, and one day we might get into it with the Jessica Yaniv situation, because at some point it makes no sense that gag orders or publication bans become the rule. They have to be the utmost of exceptions, only in cases of minors, protecting the victim, only in cases where it's necessary. But the second that publication bans on public court proceedings becomes the rule, we descend. I'm not trying to, this is not to be inflammatory, but you descend into North Korean type trials that happen behind closed doors. Nobody knows what happens, and nobody ever knows because nobody can report on it. And if they do, they get held in contempt themselves. So it was my biggest issue with Tommy Robinson, is that you're issuing publication bans like it's candy, and it's a big problem. And in this case, you can't issue a publication ban for a father to talk about these very serious national interest issues. I mean, they're so important that legislation depends on them. And you're telling a father that he can't discuss it, and he can only express his own personal opinions to his own close friends, to the extent that everyone knows not to disclose it, or everyone knows not to disclose it to the media or whatever. I mean, that's basically like saying you can have your opinions, you just can't say them out loud. Think them in your head. I'm not going to tell you. You have total freedom of speech and thought, so long as it stays in your head. I think you have freedom of speech to the extent that it doesn't hurt other people, and to the extent that the father could discuss the issues without naming the doctors who would then be the objects of harassment. I don't care if you think that it's appropriate. It's never appropriate to harass people for doing their job, period. MXR situation is another good one. Let's remind me to talk about that. It's never okay. It's never okay to dox and harass, period. So to the extent that the father the order says you can talk about it, you just can't identify people because this is a touchy subject. Everyone feels passionate about it. And darn well by naming people, they will get doxed, harassed, and etc. You can't do it. So that would have been a reasonable limitation in my mind. That would have been the good order. The Court of Appeal says, no, you can talk about it just privately. Nobody can share it, and you can't go public with it. And that, I don't agree with it. But who knows? This might go to the Supreme Court, and the Supreme Court might say exactly what I just said. That would be great if they did that, because I make various predictions. I think I'm doing pretty well on the internet, actually. But okay, Dame of Damas says the physician's credibility should be examined about informed consent. Most doctors don't suggest therapy to minors. Okay, don't suggest therapy, and we mean transition therapy. So did I miss a super chat? That's what I want to know. I see that one right there. I got Dame. Oh, was this an old super chat? I seem to be lost in the super chats. Okay, if I missed a super chat, I apologize. So then let's get into this. These are the big issues. I don't know what that is. These are the big issues. The consent issue. I mean, these are logical things, and I screenshotted a bunch of comments, and I think I'll remember them. If I don't, put them in the comment section. This is where I have a logical issue, is that you have doctors who are diagnosing, first of all, teenagers, and I don't say this to be demeaning. Teenagers may have made decisions. When teenagers become adults, you realize when you were a teenager, you made decisions that you would never make at your current stage of life. In 20 years from now, you will certainly have made decisions 20 years earlier that you might not agree with 20 years later. But there's some science. There is objective science that the brain doesn't, is not fully developed until you're 25 years of age, et cetera, et cetera. But when you have medical, the whole idea of this Infants Act, this is let's step away from the transgender aspect of this. You have an Infants Act that says that doctors are going to approve of the consent of an infant to certain treatments if the doctors feel it's in their best interests, notwithstanding parental opposition, if they deem the infant's consent to be valid. Where was I going with this? You have in this particular, then you get into the situation where you have infants, an infant who has been diagnosed with a clinical diagnosis, gender dysphoria. So whatever that means about the workings of the brain, you have the doctors diagnosing a 14-year-old with gender dysphoria, which is I don't want to say mental disorder because that carries with it a lot of baggage, but it's a clinical diagnosable disorder. That's why it's called gender dysphoria. They determine this problem. The child, on the other hand, in addition to this, the child has attempted to commit suicide because of the severity of the dysphoria. And then the doctors nonetheless validate or ratify or approve of the consent of the child to this, what is objectively life-altering treatment. It just depends on the extent of the life-altering treatment. It's very counterintuitive to, on the one hand, diagnose someone with dysphoria and then rely on their ability to consent to life-altering treatment. I mean, it's a fundamental incongruity with the issue. Okay, Corey Flood, thank you very much. Says 10 to 15 years after surgical reassignment, the suicide rate of those who had undergone sex reassignment surgery rose to 20 times that of comparable peers. So therapy would be more beneficial than hormones, etc. Well, let's even say, okay, I don't know about that. I've read it, I've seen it, and I've seen it on a number of places, but I don't even know. Let's just say that there is no difference. First of all, thank you very much for the super chat. It's very generous. And let's just say that it's even equal. And then the question becomes, what's the best course of action? The reality is, and this is where I get into this, the difficult human aspect of this. You might be dealing with bad versus worse in terms of situations, and then you're making your best guess. You have someone with a diagnosed clinical dysphoria who has attempted to commit suicide. The risk is that if the individual is not given the treatment they think that they want at that point, they'll try to commit suicide again. And so the risk is suicide. The flip side is if they get the treatment they think they want at that point, later on down the line, the risk is suicide. And this is why I say, like, it's a fundamentally difficult issue to deal with, because you might be dealing with the lesser of the evils and you don't know which one that's going to be. Obviously, the question then is going to be like, the lesser of the more reversible or the less irreversible of the treatments is obviously the best. And I think everybody would agree with that. The question is, everybody, by the time a 14-year-old has already tried to commit suicide and is now seeking what they think to be the solution to their problems, you are in the stage of crisis. You're in the heart of the crisis where your alternatives in your mind and maybe even in reality is another attempted suicide or this. And so there can be nothing less extreme. Let me rephrase. There can be nothing less irreversible. There can be nothing more irreversible than suicide. So let's just try this, because that's what we're faced with. As opposed to, I don't know how proactive the therapy would have to be in order to prevent another attempted suicide, to get through this period, the crisis period, so that more enlightened decisions or more mature decisions can be made. But like that's the reality of the situation, and you're sticking this in front of a judge. I mean, it's an impossible situation, which is why you have these extreme situations that people try to turn into the new standard when they have to be regarded as the most extreme situations to begin with. I took notes down. I think I'm getting to everything, but so I mean that's the issue. Is like, on the one hand, this Infants Act. Yeah, people are asking, hey, let's just say a kid comes in and says, I really need to drink alcohol. It's like, it's what I need to do right now. It's in my best interest. Let me just find a doctor who recognizes, who also agrees it's in my best interest, and I know the risks. If I drink alcohol, I'll stunted growth, liver cirrhosis, liver, etc. But I'm prepared to accept that, good, cleared consent. And, let me drink alcohol. People use the word tattoos. I mean, not the word, but people use the example of tattoos. Like, let me tattoo my face. I have body dysmorphia, anorexia. Like, I know it's in my best interest. An anorexic needs liposuction because that's the dysmorphia. They have body dysmorphia. Like, you can think of analogies. They're never going to be perfect, but they're going to be pretty close. But they illustrate the risk is the solution, is the best interest solution to cater to the dysphoria, or to respond to the dysphoria, or to, give therapy. But at some point, it's like these are impossible situations to deal with on a human basis. And then you have divorced parents not communicating, and then you throw all this in front of a judge, and you expect the judge to get it right. The family couldn't get it right in the first place. And so it's easy to fault the judges, but man, the family couldn't get it right. And then they stick all this in front of a judge who, within, bearing in mind, by the way, within 2 months, has to learn the family history, the ins and outs, the nuances, and then has to render a decision. And then people poop on the judges when they don't get it right. It's an impossible situation. Okay, so that was. Let me see. I'm going to get to some of the questions that I screenshotted. It's a very. So what ended up happening in this decision the kid AB is going through the hormone therapy, and we'll see where it goes. From what I've heard, a bunch of things that like the hormone therapy is irreparable, or it causes irreversible side effects. I've heard that it doesn't actually make things better. I don't know if suicide rate is worse, but I've heard that it's certainly not better, however many years down the line. But these are like extreme situations of people going through things. It just so happens that for whatever the reasons, the transgender issue in particular has become a national legislative political issue. And so that's why this is all hitting the fan as relates to the transgender aspect. Matthew Maddox says, in my case, my dysphoria is linked to my depression. The more my depression hits, the more I hate being male. Guess which one needs to be addressed? Well, I mean, and it's an impossible thing to deal with, because you're saying there is psychological distress that needs to be met on an immediate basis because people can't deal with it. But then people are saying like, well, but the treatment in the long run doesn't actually resolve anything. But you have to get through the short term before you can get to the long term. But it's just, I mean, this is turning into something that I can only relate to as a human. I've never had experience with this, but this is just to sensitize everybody to what the judges are dealing with when they have to render these types of decisions. The truly shocking part. Sorry, so that was Matthew Maddox. Thank you very much, and let's thank you for coming in. And thank you for sharing. The human element can never be ignored. Steve Steven says, you told me to watch your videos at 2x. You failed, but keep doing the live streams. Thank you. Yeah, no, nobody should watch my videos, my normal videos at 2x. So that's where the Court of Appeal went. That's their decision now. I don't know if it's going to the Supreme Court on the freedom of speech aspects of it. But it's that. So that's where it stands now. Where everybody's getting shocked. Let me just see if I can get some more of the questions. So one, and I'm not going to read the names just because people leave comments and I don't necessarily want to put. I keep using the expression, but I want to read comments without putting the person who made the comment on blast. If a minor is now viewed as an adult enough to decide medical treatment, then they are adult enough to be tried in adult courts. Oh, thank you very much for reminding me about that. This whole thing about like minors consenting to treatment as though they're adults, so there's two things: emancipation and criminal stuff. So emancipation, I have to refresh my memory. I think a minor can petition the courts to be emancipated. That is to say, be regarded as an adult. Hold on, I'm going to cough. Excuse me. They can petition the courts to be regarded as an adult. They're mature enough. They want to move out of the house. They want to have their full rights as an adult. They petition the courts, and the court will adjudicate. Are they mature enough as a minor to be emancipated so that they can exercise their full rights as adults? And they do it. I think sometimes, typically people do it. There's simple emancipation and full emancipation. But then people do it at 16 to get married. So the courts will recognize major civil rights of an adult to a minor if they petition the courts and the courts are satisfied that they are sufficiently mature. The other thing is in criminal law, it happens all the time that minors are tried as adults when they're deemed to be sufficiently mature, aware of what they've done. But again, first of all, these are exceptional cases, and they are in the case of emancipation. It's sort of it's like a proactive case where someone's saying, "Look, I'm so mature, recognize me as an adult." Whereas in the case of the Infants Act, we're talking about people who are suffering from medical conditions, petitioning the courts to say my consent is valid to certain treatments, which they might not wish they had gotten 10 years down the line. And then in criminal cases, well, you're just dealing with people doing bad things, and then it's just a question of how to attribute responsibility to them in a responsible manner. Okay, H7, HJ, 59, FH, 35. If AB had been born as a boy and the father raised his son as a girl with feminine pronouns, wouldn't that be psychologically abusive? I think that's the lens through which the lower court viewed it. So, first of all, H7, thank you very much again for the super chat. So there's a separate actually, I don't know this fact. I read it in the comment section, and apparently it may have been reported possibly as a result of the father disclosing more private information than ought to have been disclosed. I don't know. And I should caveat that. I have no idea. I just saw a comment that said that apparently there were issues of psychological abuse by the mother towards the AB, which might have accounted for some of the psychological issues. And apparently it was the mother who was, who was pushing this narrative story. You never know this because when parents get divorced, one is going to say bad stuff about the other. But sorry, so let me get back to that. So in this particular case, I don't know if the mother was promoting it, encouraging it, egging it on, or even provoking it. I don't know. But look, the psychological abuse, again, is also determined on a case-by-case basis. But these are extreme cases where, like, what is psychological abuse? Having a parent tell their kid they're fat and ugly and stupid on a daily basis, they're just words, it's just freedom of speech, but it will qualify as psychological abuse. And you could understand a court even removing custody from a parent who so psychologically abuses a child, even with words. It's freedom of speech doesn't authorize anything just because it's spoken. That's the argument or the back and forth that I have with a lot of Americans, because they're very much pro First Amendment, which I understand. But people have the idea of thinking, well, freedom of speech, I can say and do whatever I want. Yeah, but speaking words to your kid is one thing. Speaking words of abuse and psychological abuse, courts get involved, judges get involved, lawyers get involved. So where were we? Sorry, I'm going to get rid of that. Thank you very much, by the way. F7. Okay, I can't. There was somebody's name. I almost. Having a parent tell a kid they are fat or ugly is abuse, but having a parent tell a kid they're born a boy when they're in fact a female is not. Look, first of all, I agree with the first part, but imagine a kid saying, imagine a kid, because the religion, it's funny, religion is always the example people go to, but imagine a kid converting and then having a parent refuse to acknowledge their conversion. And they say, like, not a minor kid, but let's just say it fails on the analogy because minor versus adult, but I can't think of a good analogy because we're dealing with, on the one hand, objective verbal abuse versus biological composition. Imagine having a father who just parent who consistently refuses to validate their kids' choices. It can be abusive to the point where the kid's going to say, I'm cutting off communications. That was it. Cutting off communications, which incidentally is the ultimate paradox of the first court orders in this file. Is the judge says, Judge Bowden Marcia, the first two court orders said, this kid has gender dysphoria, diagnosed clinical gender dysphoria, has attempted to commit suicide, is mature enough to consent to the risks of the treatment, but on the other hand, can't have the father refer to the child as a her and try to talk the child out of the procedure. There's so many mutually incompatible, and this is where I asked on Twitter today, like, what the definition of cognitive dissonance was, because I saw the comment come up and it's like, I don't understand what the word means, but like, now I understand what cognitive dissonance means. It's like, you have a set of beliefs, you see some facts that contradict your set of beliefs, and you nonetheless fight to maintain your set of beliefs. You have the judges recognizing a clinical mental dysphoria, coupled with attempts of suicide on the one hand, then validating the ability to consent to life-altering treatments because of maturity, and then at the same time saying, but the father can't say certain words to this kid because it's so upsetting. And the court of appeal in a way got it right. They said, look, this kid is mature enough to consent to the treatment. They are mature enough to hear these words spoken from their father, which is why it can't be family violence. It's not the father swearing, cussing, expletives. It's the father saying words that a mature enough person should be able to deal with. And they got it right to some extent, but not to the extent they should have. Okay, Repo Shit says, Bill C-16 coming up at all? Merca recently had a similar case in Texas that got some attention. I appreciate your sensitivity while speaking. Thank you very much. Repo Shiz, taking your stuff. That's what he means. Bill C-16 come up. Which one? Bill C-16 was the Peterson forced pronouns one, if I'm not mistaken. I did a video on that. We're getting into the aspect where laws are interfering and, if not usurping, parental guardian obligations, and where you can see the power of the courts. And everybody in the States, they say, like, oh, you're crazy in Canada, your courts are out of control. They issue these. It happens everywhere. When you end up in front of a court, you are at the mercy of the court, and you're at the mercy of the court subject to the powers of revision of the higher courts and the highest court. It's no different. It's no different in family law. It's no different in civil law. It's just like these issues, people politicize these issues because they are political issues and they have political ramifications. But crap, why would there are crappy decisions in civil law? Why would there not be crappy decisions in family law? Like that's there are good decisions, there are bad decisions, there are untenable decisions that get overturned in appeal all the time in civil, commercial, corporate law. Why would it be any different in family law and human rights law? I mean, it's the expectation is that somehow the more fundamental the principles of law and the more fundamental the issues, the courts should get it righter, so to speak. You're in front of the courts, you leave it in the hands of the court. Doesn't matter if it's a lease issue or a gender transitioning issue. You run the same risk of having a judge get it right or wrong and be affected by the same things regardless. What else did I miss? Let me just see if I missed anything in terms of the comments. If anybody has any questions, get them in there before we're getting close to the time that it should be to wind this down. And we hear here, someone said, I think preventing the father from referring to the child by certain pronouns or dissuade them from going through the treatment is justified. Preventing the father from talking about the same with third parties violates freedom of speech. That doesn't include revealing personal information to third parties against AB's will. Family violence judgment should obviously apply to a parent referring to their child by gender. So, I mean, the bottom line is we can all agree on this. Like, we can all agree on the basics, but when you get it in front of a judge and the judge has seen maybe some behavior, maybe they're not inclined to give anybody the benefit of the doubt, and maybe they know that they can't give the other party that latitude because the other party is not, based on past conduct, is not going to use that latitude responsibly. Okay. I think we've done a good job on that. Is there anything else while we're here that we should talk about? People should be allowed to be assholes, but other people should be allowed to call them assholes too. That is a very, that's the first one I pick up as a comment. Gino Cho says, thank you very much for this important live discussion. Thank you. Look, thank you. This is the thing. It's like, these issues have become politicized. Politicized is not necessarily, that's not where it gets bad. Where it gets bad is when things get politicized, they need to be summarized in a tweet, and they need to be polarized in a tweet, and they need to be, what's it called when you reduce when you reduce a sauce when you're cooking. They need to be reduced to sound bites, and some of these issues cannot be. Bottom line, that Infants Act in British Columbia, transgender issues aside, that Infants Act to me is if I were to be elected, I'm not going to British Columbia, but that I would repeal that and replace it. That Infants Act, it's inconceivable to me that medical professionals, depending on what is the trending medical theory of the day, that they can determine the best interest and then ratify the consent of a minor to therapeutic or cosmetic invasive procedures. Sorry. If I'm doctors are entitled to their opinions. But if we're not talking about necessary surgery, necessary vaccinations, necessary medical procedures that are, failing which there will be irreparable harm on the natural order of things. An infant, hell or high water, is not going to be able to consent if the two adult parents don't necessarily think it's in the child's best interest. And I see a Princess Bride. Inconceivable. Yes, look, if I see Princess Bride, I'm pulling up the comment. So that Infants Act is, as far as I'm concerned, we don't have the same thing in Quebec, which is why I was shocked by all of this. But we don't have, as far as I know, we don't have anything similar to that in Quebec. We have emancipation. If you want to get emancipated, go to court, be recognized as an adult. You're responsible for all of your actions. A lot of people are asking, okay, good. Who's paying for the hormone therapy? Who's paying for the kids' upbringing after this happens against the parents' will? If the state wants to take over treating, diagnosing, raising the kids. Like, okay, then these become kids of the state. But the whole fundamental issue, these are extreme, exceptional cases. But because the media is what it is, and because the world is because social media is what it is, these exceptional 1 in a million cases become like they become perceived as the norm, and that's it. I mean, it's. Did that? I think you missed 4 super chats, 2 by the same guy. Who was the guy? Who was the guy? Please. There's nothing that will keep me up at night more than missing a super chat because it makes me feel bad, and I have obsessive. I'll feel bad. So I can't scroll back past this comment, Charles Crawford. If I missed the super chat, please somebody tell me who it was so I can get to it. Son of a bee sting. The real Bambunga? The last super chat I see was Corey Flood. Okay, the real Bambunga. Can someone, Bambunga, can you post your comment right now? I want to get to it right now because I will feel terrible throughout the night. Okay, I'm going to wait for real Bambunga's. Real Bambunga, incidentally, was in the last live chat, and I way back. Okay, I missed it way back. Sorry, man. Post the question again right now. Don't post another super chat. Just post the question. I'm going to get to it right now. Thank you. First of all, real Bambunga, thank you very much. It's good to see you again, by the way. Let me look. Okay, he's gonna go pull up the question. So that's it. I mean, it's a sad situation because it's the most personal of medical issues. It's the most personal of it's the most personal of everything. And then it's brought to the public sphere where it's scrutinized, ostracized, politicized, and these people with real problems, they cease becoming people. They become objects of public domain material, which is why you keep your freaking kids out of politics, and not to get into the Greta Thunberg, which is why kids should not be in politics, and which is why, can the child consent to assisted suicide using the same law? Also, you missed the last super chat, the real Bambunga. Okay, so if that was the real Bambunga's question, assisted suicide, I don't know. First of all, no doctor is going to determine that assisted suicide is in the best interest of the minor. So I'll go out on a limb, not knowing more than that. That's what I'll say. But I'm just trying to think of no doctor is going to conclude that death is in the best interest of any minor. Okay, can the child consent? Okay, good. Bambunga, thank you very much. Sorry I missed it. Reduce, seduce, and reuse. Judge aftermath metaphor. Okay, so that's it. These are like these issues, and which is why, on the one hand, I understand the need to discuss them publicly, but then social media mobs being what they are, you understand the risks of discussing them publicly. MXR, by the way, doxing people. This is why discussing things publicly. Back in the day, you'd write an article in the Gazette, like a newspaper. People would read it, and that's it. Today, you publish something publicly. The father goes and goes publicly. You mention a name, and a tweet can mobilize 1 million people. And over this issue, transgender hormone therapy, judges, doctors, medical treatment, MXR, for their stupid $6,000 invoice for alleged copyright infringement, mobilized, through the help of viral videos and other platforms. They mobilize people to dox and threaten employees of Juke and family members over invoices. And you can imagine what can happen over issues of transgender hormone therapy for teenagers and the doctors prescribing it. Now, a lot of people have been right. Okay, so the last super chat I see was Corey Flood. No, sorry, there was one after that. If I missed anyone, okay, well, anyways, that's it. If I missed another, I'm looking down to see if I see him. But you imagine for an invoice for copyright infringement, they, hundreds of thousands of people were mobilized to harass, email, dox, threaten employees of Jukin, family members over a few $1,000s, and now we're talking about transgender hormone therapy, the doctors who are doing it. It's I don't want to say it's a dangerous world, because ultimately, ultimately online harassment, people don't take it seriously because they think it's online. It has less of an impact on the recipients when it doesn't. But online harassment is sort of it's different to some extent, but it's still serious and it shouldn't be taken lightly. But you can imagine. I mean, it's not. These are real considerations. And so when you have a father violating a court order, identifying the doctors, you can see how it can escalate quickly given the momentum of social media. Repo shiz, you're great. If anyone attacks you, we're here. Nobody. I'm not worried about being attacked. I mean, first of all, thank you very much. I'm not realistically worried about being attacked. I have my own things, but I'm not realistically worried about being legitimately attacked, I should say. But the internet is just, it is what it is. Like it takes on a life of its own. And with Jukin, you saw the life it takes on. Imagine what it takes on in this type of situation. Now, the other issue, there are things to be discussed, like what doctors, who are the doctors, how many opinions did they get to decide that it was in the child's best interest? Who are the doctors making these decisions? Because let's move away from the transgender aspect of it. Let's just go to dental hygiene. You will always have doctors saying it's in your best interest to have braces, to have you have receding gum line. Let's do this. Doctors, I feel cynical. I feel like my father almost by saying this. Doctors don't make money by not working, so to speak. So thank you very much, Jack Martinelli. Doctors don't make money by not working. So obviously, like doctors, lawyers, it's make work. So if they have no work, they don't get paid. So yeah, okay, fine. Hey, look, the newest technology of the day, receding gum lines. Oh, we take flesh from your butt and stick it on your gums. Okay, that's in your best interest today. And then we find out, 5 years from now, that was no more effective of a solution because the tissue is different. It doesn't, whatever. You can see the medical procedures, the medical recommendations, the medical thought of the day is very much dependent on the day. And so when it comes to something as severe and as irreversible as hormone therapy for gender dysphoria, the question does become, who are the doctors prescribing it? Why are they prescribing it? And are they, is there, I don't want to say a commercial interest in prescribing it, but is there something, is there, I don't want to say an agenda? Is there another underlying reason for which this is being prescribed at this particular era of humankind? Steve Stevens, just because my past fiance was a Habs fan and we're a fan of yours. Also, I'm a Blues fan. Blues. St. Louis. Yes. One of the original 6, I think. Thank you, Steve Stevens. So that's the other question. The medical professionals, who are they? Based on what are they saying this? Is this the flavor of the day in terms of medical accepted knowledge that, this is what we're talking about today? Like we were talking about focusing on diet soft drinks 10 years ago. And then we find out that aspartame is just as bad as sugar, if not worse. I mean, this is the whole thing, is things are in flux. So who are the doctors? How many opinions did they get in this file? These are questions I don't know. But that's it. So that's it. I think we've done the survol, comme on dit en français, de ce dossier, de this difficult file. What time is it? Okay, we're going to go no more than 8 minutes. At 11:30, we are out of here. So we're going to taper it down, let everyone wind out. Let me see here. I'm pulling up comments before I read them. So if they say something terrible, I'm going to apologize in advance. As a father, I'm horrified that government and medical professionals can team up against what I feel is in the best interest of my child. It feels like a huge overreach into my right as a parent. I don't think anybody's going to disagree with that. But I don't think anybody's going to disagree with that. And then the flip side is, let's assume that let's just take the situation where the kid has legitimate issues that the parents illegitimately oppose. And I don't want to single out anybody in particular, but God, it's so difficult to find examples that are not going to get me in trouble. Let's just say that there are situations where the parents are, for their own belief system, are refusing treatments that are objectively recognized as necessary. That's what the law was intended to cover. That's what this was intended to cover, where the parents are negligently not following through proactively on required treatments. But that's that's the slippery slope that everybody talks about. It's you go by the inch, but not by the mile. Okay, then we have these laws that say okay, but now the judge is going to impose it on something that is not technically absolutely necessary. Not like a tetanus shot after you've cut your hand on a rusty nail, or not like a rabies shot after you've been bitten by a bat. But now it's a shot to not get chicken pox as a kid, and then it's okay. That's fine. And now the judge says, okay, well, we've done that. So now, if the kid says the kid needs hormone therapy or they're going to commit suicide again, and the parents oppose it, well, geez, the doctor says it's in the best interest, and what are we to do? We faced with potential suicide versus hormone therapy. It's like, yeah, it's an overreach in the cases where it's an overreach, but the law had an intended purpose, which was to protect against abusive or negligent parenting. So it's not that it's black and white. It's just that it's gray. There are gray zones. There are black and there's white, and then there's the issues that make the news somewhere in the middle. Let's see what we got here. Sorry, that was not the question I was looking for. My big issue with all of this is still the compelled belief. Dad was given a court order to use a specific pronoun, which isn't just forcing him to say something, it's forcing him to have a belief. There's no question. The Court of Appeal said as much, but it had to get to the Court of Appeal. That's the problem. It's like, okay, yeah, you're right. And the Court of Appeal said you're right. But imagine this dad didn't have the resources, it doesn't matter who it is. Imagine this person didn't have the resources to get to the Court of Appeal, and we were stuck with this decision of Bowden or Marcia, which never got to appeal, and which became jurisprudence that this was a legitimate court order. I mean, that is where it does get shocking. Like that it became jurisprudence because no one took it to appeal, that using a gender pronoun that a trans person does not identify as qualifies as family violence. And then it qualifies as violence or harassment. And I did a video on this also, which was oddly enough, a British Columbia decision of a trans person who was arrested, and the police referred to the trans person as not their gender of choice, and it was deemed to be harassment. We get there. You get there because courts are imperfect, and then you just hope that the higher courts get it right if it gets to the higher courts. But if it doesn't get to the higher courts, because an appeals cost $15,000 to $30,000 easy Canadian, which is nothing for Americans. But yeah, you're David Johnson. You're not wrong. You're not wrong. I mean, that's it. Enforcing pronouns preference in theater of the absurd. Is theater the absurd? Yeah, it's yes, but then you get into situations of just harassment where the harassment materializes itself by that. For example, like just imagine every day and all day you go to school and you go to the person who wants to be identified as a she, and you go in the person's face, you say he. You're only using words, but anything can be turned into harassment. It's just not. It's not at that point. It's not the pronouns per se. It's just the behavior. Okay, David Stone, no comment, but thank you very much. You look like you're at the Grand Canyon in your avatar, if I'm not mistaken. Devin, let me know if I'm right. This is what got Jordan Peterson. First of all, thank you very much, Devin. This is what got Jordan Peterson into trouble. Where did that comment just go? Here. This is what got Jordan Peterson into trouble. Yeah, look, this is my thing. I think what gets people into trouble is the manner in which they express themselves, and not necessarily the substance of what they're expressing. And it's like the issue I have even with people that I interact with on the Twitterverse. And some people, they make good points, but they make it in a deliberately offensive, I don't want to say offensive, but like shocking way. And I think it's more the delivery than the substance. But no, gender, look, Oscar Peterson. Jordan Peterson definitely talked about this. Okay, there's somebody whose name is FU, which I can't actually pull up here, but misgendering is not harassment if it's by mistake. The law, hey, let's live dangerously. Misgendering is not harassment if it's by mistake. The law says it's harassment if it's repeated after request to the contrary. Yeah, any verbal tirade against somebody can be harassment. It doesn't matter if you're saying he or she. If you just go up to someone and call them a shrimp or a nincompoop, any sort of any words that are, anything can become harassment. It's not the words, it's the act. Okay, here we've got here the real Bambunga. Thank you again, thank you, and again, sorry. The real Bambunga. My other question was basically that you keep saying that the bell can't be unrung. How do you figure? I can't find the kid's name or his father's name. Seems like the publication ban worked. No, Bambunga, I can tell you that I've gotten the names. People have sent me the names of the doctors. People have sent me the names of the kid. No, but that's just I haven't been looking for it. But people have sent me the names of the doctors. So, and look, I guarantee you, I could find it. It's not like I'm not an internet search wizard, but you can find it in 5 seconds. You can email somebody and get it in 5 seconds. You could pull up the Federalist archives or Culture Guard archives. I'm sure you could find it. There's no question you can find it. So anybody who wants to find it will be able to find it. People who are not that interested, yeah, it's not going to be at the tip of their fingers. So it can't be, and that's what I mean by it can't be unwrung. And even if it can be, let's say you pull the articles, because they did, in fact, I think part of the order was to get the Federalist and to pull the articles or to redact them. But the other thing is the bell can't be unrung in the sense that the damage is already done as well. So the harassment may have already been incurred. The people who are the ones who are really going to harass the doctors already have their info, and then they have to change their numbers, their addresses. It leads to a whole bunch of terrible things. So that's what I mean. The bell can be silenced. You can put a silencer on it, but the bell's still going to make noise. Did I say I'm already past? It's 11:30. I could do this forever, but we should probably go. Okay. See, I thank you very much. I could do this. The great thing is, like, when I get comfortable with the subject, I can talk about it for a while. It takes a long time to get comfortable with the subject, and it takes a long time to actually learn the substance of it to have a bona fide, legitimate, meaningful discussion about it. Off topic, YouTube change notifications. Might want to mention that something about that. You have to check the bell, then hit all. Everyone hit the notification bell. Yeah, no, I've noticed things with YouTube. Thank you very much. Yeah. Bambuga says, I'm past 8 minutes. And Rekieta Law is coming on. Here, let's do this. Rekieta Law. What? I can't see anything. Oh, stop it. Okay. Rekieta Law is, why won't this not work? Oh, whatever. Nick Rekieta is having a live stream soon. So you can watch him if anybody wants to stay up until 3 a.m. I did a live stream with Nick Rekieta last summer. It started at midnight Montreal time. I was up until 3 a.m. It was crazy. Rum Becker? No way. Hello from westbound Quebec. Hello. Look for me walking my dogs. Thank you, Rum. Real Bambuga says it's 11:31. Okay. We'll get a few more questions. No more few questions. Let's just see. Viva, consider DNR orders for brain injured kids. Similar difficult decisions for parents and doctors. I'm going to look it up because I don't know what. Oh, do not resuscitate. I'm sorry. Imperfect decisions do not make for perfect law. I mean, that's just to say it that way, to say it obvious. Okay. Here, let's see here. This actually a better response is it's more the delivery than the substance. Only for listeners who aren't looking to be offended. Look, but Jeff, I can tolerate a ton of. I can tolerate offensiveness, edginess, crassness. Some people can't, but I think the issue is a lot of the times the people who end up getting in trouble on YouTube, Twitter, etc. It's not so much for the substance of what they're saying, but rather for the sass with which they say it. And I'm open with them about it. Like I can think of a bunch of people who are very edgy in the delivery of their content, even if their content is basically common sense. And I say to them, just if you deliver it as common sense, you wouldn't get into these problems. But then the problem is, who knows? Maybe they wouldn't grow as fast if it were just delivered in a different manner and, whatever. Okay, hold on. There was one more before I forget it. Jeff, thank you for the comment. Robert Gonzalez, hello from Arizona. I love your videos. Keep up the great work. Thank you very much, Robert. Robert, Arizona. Look up, by the way, right now, if you could. I believe it was called Personifying the Saguaros, because we were in Arizona a couple of years ago. We were in there twice. It might be the most beautiful place on earth. If I ever moved out of Canada, I would think about moving there. We were in the Saguaro National Park, and I was replicating the shape of the saguaro cacti humorously. Thank you for the super chat. And Yeah, you're lucky. Arizona's beautiful. Let's see here. Too many people want me to cuss like Annie Wilkes, the real Van Gruga, and it just ain't gonna happen. I don't think it's. I don't. It does. Look, I say this as someone who's been struggling on the platform and I've been growing fast enough, but like, who knows? Maybe if I were more like Mark Dice or I don't want to. I'm not trying to like make fun of anybody because it's just, or even Ezra Levant. These guys, I think if they toned down the rhetoric, they would avoid the problems. But who knows? Maybe they wouldn't be as popular as they are if they didn't do it the way they do it. Okay, so that's it. 24-hour live stream, yay or nay? One day. You know what? 1 million subs, I'll do it. Did I just commit to that? 1 million subs, I'll do a 24-hour. I can't even finish the sentence. That might be too much for me. Dice is immediate. Look, people make good points. When they make good points in bad ways, nobody understands the good points. That's what I seek to avoid on the platform. Even if making a good point in a bad way gets more retweets. Anyways, but whatever. It's a question of choice. And it might be a question of personality as well. That's it. Okay. Who skipped? David Johnson skipped the original super chat. Did I skip someone's original super chat? Okay. Viva Fry, too late. Already saved the commitment. 24-hour live stream at 1 million subs. What could I do for 24 hours? I could fish. I'd have to be in a place that had 24-hour sunlight. Oh, from Uncivil Law. Okay, no. I got to one from Uncivil Law. If I missed another one, could you repost this comment? No, I'm certain I talked about Uncivil Law, unless he did 2 super chats. In which case, if he did Uncivil Law, I'm sorry. Let me see if I can get to the comment before we end it. We gotta end it. We gotta do it. Okay, yeah, Rekieta is going live in 30 minutes. You guys got to go watch another YouTube lawyer. Okay, people. Oh, here we go. Steve Stevens says, green or blue, no hues, just straight green or blue. Need answer now. Green or blue, no hues. Blue. No. Blue. I said it. I have to stick with it. That's what you meant, right? Like just color-wise? Blue. There were scientific studies that show that vast blueness has a calming effect on the soul. Fuck you. If you don't forget, I'm bringing you up here. What about a video game-a-thon? I have the Nintendo NES. I can play Double Dragon 2, Mario Brothers 1, 2, and 3. Okay. We have an idea. Let's get to 1 million and we'll worry about it. Charles Crawford, I picture VFI wearing a helmet with a GoPro for 20 hours straight. Yeah, but then I have to live stream through the GoPro for 20 hours straight. I have to have Wi-Fi. I have to have GoPro goes dead after 45. The new one goes dead after an hour and 15 minutes, so that won't work either. Real Bambunga says, not true. When Windows shows me a blue screen, I am not calm. Okay, touche. I'm down for a retro game time. Yeah, I only have NES in the house. We have Mario Brothers, we have a bunch of games, but some games are so bad. Golgo. It's like a Russian communist infiltration game. I've never even understood it, even when I played NES. But my favorite is Double Dragon 2, but I've finished it too many times now. Viva Fry live stream 24 hours at 240,000. Yeah, 48 hours at 400K. I can play poker for 24 hours straight at a casino. I see, what's the word I'm looking for? Collaboration here. I swear to you, I can play poker for 24 hours straight. Easy. Haven't done it ever, but I know I could. Okay, done. People, by the way, I've been subscribed since you had 15,000 subs in 2018. Rachel Transgirl, do you remember, I think it was 20,000 subs, or was it 10,000 when I had Pat Sajak in San Diego? And then 20,000 subs. Oh, man, you've been here for a long time. That's crazy. How have you appreciated the transition of my content? I'm curious. I feel bad because some people who originally subbed must have been here strictly for like cooking and fishing and stupid stuff, and now it's all law. And I kind of feel bad that maybe I'm like betraying the original subs. But I think I found my Ikigai, and I'm going to do my video on Ikigai sooner than later. Jim Payne, dude, make Double Dragon 2 happen. Okay, I can do Double Dragon 2, dude. I will do Double Dragon 2. I will play it until I finish it, not by cheating and starting with 2 men and then killing my brother and taking in all his lives, so I start with 6 lives. 1 person, 2B, Ultra Mode. Kill it. We can do it. Devin says, you should play Sofa King. What do you think? I haven't seen that episode of Saturday Night Live. But if the Sofa King can make it on Saturday Night Live, because they make great... It was the Sofa King. It was on SNL. But yeah, my Dixie... Oh yeah, Wrecked. That was the second part. Okay. Tecmo Bowl, by the way. Who said that? I have Tecmo Bowl. Okay, there's so many things. Okay, we've got the 24-hour live stream. It's either at 240,000. It has to be at 1 million. I can't do it at 240,000. It's too much of a commitment. Wait, I missed something here. Yes, when anyone's screaming, you have to pull it up. We got... Okay. Okay, let's do it. We're going to call it quits now. Thank you very much for the live stream. Thank you for tuning in. Thank you for the super chats. Share the channel. I mean, that for the time being, to get to 1 million. Either everyone needs to share the channel, or I need to get like Elon Musk to retweet one video about Elon Musk, or Joe Rogan. I don't think I'm interesting enough to be on Joe Rogan just yet, but one day. But anyways, to get to 1 million, I need like just it's all by like steps. You have to get to the next step. You win. Just having fun. Love you, Devin Stone. Okay, Devin, thank you very much. Let's do it. Gino Choi, thank you very much. 1 million. It's going to happen. It's just a matter of time. But I have to be able to tread water until we can reach the island. Okay. On that note, I hope you learned something. I hope you liked it. I share it around, discuss. Always keep it civil. Always keep it respectful, even if it's easy to resort to Twitter sound bites of discourse. Twitter is not how humans were meant to interact with one another. So, okay, on that note, I'm going to put my thumb and say peace out. Peace out. Thank you for tuning in, and see you soon.